Hello and welcome to this FedSoc Forum webinar call. Today, January 29th, 2025, we're delighted to host a discussion on remedies in presidential removal cases, a shifting landscape. My name is Kayla Kleist, and I'm an Associate Director of Practice Groups here at the Federalist Society. As always, please note that all expressions of opinion are those of the experts on today's program, as the Federalist Society takes no position on particular legal or public policy issues. Now, in the interest of time, I will keep my introduction of our guest today brief, certainly more brief than their careers would deserve. So I highly recommend that if you're interested, you check out their impressive full bios at fedsoc.org. Today, we are fortunate to have with us Dr. David Froomkin, who is an assistant professor of law at the University of Houston Law Center with primary scholarly interests in administrative law, election law, and democratic and constitutional theory. His research focuses on the structure of government and on democratic processes, drawing on political science, political economy, and analysis of the text and structure of the Constitution. Before joining the University of Houston Law Center, he also served as a teaching fellow and associate in teaching at Yale, and he currently teaches courses on election law, criminal law, and constitutional design. Also joining us today is Nachmany, who's an associate at Covington and Burling, LLP, in their Washington, D.C. office. Before coming to Covington and Burling, he clerked for Judge Stephen Menashe on the U.S. Court of Appeals for the Second Circuit. And prior to law school, Mr. Nachmany served as a speechwriter to the U.S. Secretary of the Interior and as a domestic policy aide in the White House Office of American Innovation. His scholarship on administrative law and executive power has appeared in the BYU Law Review, George Mason Law Review, Wake Forest Law Review, and Yale Law Journal Forum. Lastly, joining us today as our moderator for today's conversation is Christopher Walker, who's professor of law at the University of Michigan Law School. His research focuses primarily on administrative law, regulation, and law and policy at the agency level. He teaches ad law, civil procedure, constitutional litigation, federal courts, legislation and regulation, and state and local government law. Outside of his service at Michigan Law, Professor Walker serves as one of 40 public members of the Administrative Conference of the United States and is past chair of the American Bar Association's section on administrative law and regulatory practice. He is also a regular blogger at the Yale Journal on Regulation and the section editor for Jotwell's Administrative Law section. And I will leave it there. One last note before I get off your screens, if you have any questions throughout the program, please do submit those via the question and answer feature, likely found at the bottom of your Zoom screen, so they'll be accessible when we get to that portion of today's webinar. With that, thank you all for joining us today. Professor Walker, the floor is yours.
Awesome. Well, this is going to be a lot of fun. We styled this as remedies in separation of powers removal cases, presidential removal cases. I think we're going to kind of probably go a little beyond that because the news kind of, even from when we posted this a week ago, we're already in a different news cycle with a member of the NLRB being fired earlier this week. And I would just say similarly, if anyone else is fired during this, please put it in the Q&A so that we can kind of get that real-time update. But there is this fascinating issue that comes out of Collins v. Yellen, where the Supreme Court held that the removal protections for the single-headed director of the Federal Housing Finance Agency are unconstitutional for the same reasons that they were in say, the law versus CFPB. But as kind of we hinted in our description for this, what's disappointing about that is the remedy was pretty meaningless. The court said, well, you have to show, and Ellie's probably going into a little bit more detail in a second, but you have to show that the president would have fired that person, if the president knew they could have been fired, which is a pretty impossible task to kind of think through. So there's a big question of is there any meaningful reason to even bring lawsuits to challenge an unconstitutional removal protection? And how are these remedies really fit for the type of issues we're dealing with? Now, of course, in the backdrop, there's also the question of, is there even a constitutional violation? Maybe we'll circle back to that more in the discussion, but I'll start first with Ellie, and then we'll go to David, kind of a little bit back and forth on these kind of questions of remedies for separation of powers violations.
Great. Thank you so much. And I should note also at the outset here that anything that I say is not necessarily representative of the views of my employer, Covington and Burling, or any of our clients. But it's a really exciting and fascinating time to be studying these issues, thinking about these issues. The executive branch is a sprawling institution. It's made up of a slew of federal agencies that range from the Department of Commerce, for example, which we typically think of as an executive agency, to other agencies we might think of as independent agencies. The Federal Trade Commission comes to mind. But the officials who act on behalf of these agencies exercise executive power, and Article 2 of the Constitution vests all of that executive power in a single elected leader of the executive branch, the President of the United States. Ordinarily, when the president believes that an executive branch official is not doing a job properly, the president can remove that person from his or her position and find someone else to do the job. The Supreme Court's decision in Myers v. United States from 1926 recognizes that removal authority inherently in Article 2. Now, from time to time, when creating new offices in the executive branch, Congress has restricted by statute the president's ability to remove certain officials. One example, famous example of this, is the Federal Trade Commission. By statute, the president can only remove FTC commissioners for a limited number of reasons. That's a stark departure, of course, from the background rule of at-will presidential removal power articulated in Myers v. United States. When these two things clashed at the Supreme Court in 1935, the court upheld the constitutionality of the removal restrictions in a case called Humphrey's Executor v. United States, which I imagine we're going to talk a lot about today. And in Humphrey's Executor, the court carved out an exception for what it called quasi-judicial and quasi-legislative agencies. That decision has sparked criticism on constitutional grounds for many years, and the Supreme Court has largely confined the Humphrey's Executor exception. In fact, in recent years, the general trend has been in favor of going back to Myers and recognizing a robust presidential removal authority. Some commentators even predict that the court may depart from Humphrey's Executor at some point soon, perhaps even this term. But another trend is on the rise too, and it may not last very long. That is, lawsuits challenging agency action on the basis that the official enjoyed a removal protection that violated the Constitution, and thus the agency action should be set aside. Cases like Myers and Humphrey's Executor were not these kind of cases. Those cases involved specific fact patterns whereby the president would fire an executive official. The executive official would argue that his firing was illegal, and the Supreme Court would come back and evaluate whether the president nevertheless had the constitutional power to effectuate the removal. Now, several cases from the last few decades involve different fact patterns. A private litigant, aggrieved by agency action, argues that a court should set aside what the agency did because the official who carried out the action enjoyed statutory removal protection. Often, these cases make some claim or make no claim at all that the president would have fired the official in the absence of the removal protection, or that the president was prevented by a court from doing so. Rather, the idea is that the mere existence of the removal protection is a separation of powers injury, redressable by nullifying what the agency official has done. Now, in Collins v. Yellen, which is a case that I think is central to our discussion today, the Supreme Court mostly halted the practice of giving remedies in these lawsuits. Justice Alito's opinion in Collins holds that a statutory removal protection does not in the abstract cause cognizable harm to private parties who are aggrieved by agency action. Rather, Collins appears to view Article 2 as a means of allocating power between the president and so-called independent agency officials who are insulated by these potentially or purportedly unconstitutional statutory removal protections. I think the decision in Collins erases the incentive to bring a lot of these cases because the court has said that, even if the removal protection is unconstitutional, the court is not going to afford a remedy if the protection did not harm the individual litigant. Sort of you're sitting in a room that's locked, but you don't know yourself that the door is locked. Now, that said, the court's decision leaves open, I think, the possibility that a removal protection could cause cognizable harm in some instances. For example, if the president removes an agency official and a court erroneously blocks the removal by taking insufficient account of the Article 2 removal power, then maybe anything that agency official does after that could be subject to invalidation via litigation. Another possibility is the president expresses a willingness to remove the official, but believes that the statute prevents the removal. This apparent exception to Collins's rule is less certain, especially in light of a concurrence that Justice Thomas filed in that case. In any event, looking ahead, the new Trump administration seems to be interested in asserting its power to remove agency officials. If the administration removes an official with a statutory protection, that official sues, and a court order that's later overturned by the Supreme Court keeps that official in place, suppose a district court order or something along those lines, then the removal protections would arguably inflict harm on a private litigant. So I'm following closely now how the Trump administration uses its removal power, and already it has in a few instances. And I look forward to seeing how the Supreme Court continues to develop both the Collins doctrine and its removal power precedents.
Excellent. All right, David, what's your take?
So a lot of my work has argued against the unitary executive theory, against the interpretation of the Article 2 vesting clause on which these cases rest from a formalist perspective, making a mix of textual, logical, and historical arguments, arguing that the Constitution is best understood to confer substantial discretion on Congress to structure the executive branch. I take a view that's closer to that of John Manning than to many self-identified separation of powers formalists, because it puts more weight on the Constitution's text and resists placing great weight on the quite slender read of a single word executive for resolving really big questions about the structure of our public institutions. And I've done that in a number of papers. I'll just mention a couple. In one, the vesting clauses in the presidential veto, I take seriously the implications of the vesting thesis, the view that the vesting clauses are correctly interpreted as substantive power grants. And I apply that logic to Article 1, which has received less attention. And I claim that it produces some serious tensions in the structure of Article 1. The Article 1 vesting clause says all legislative powers belong to Congress, but Article 1 goes on to vest the presidential veto in the president, seeming to contradict the plain text of the Article 1 vesting clause and casting doubt on whether the vesting thesis is really a good way to understand the function that the vesting clauses are playing in the Constitution's structure. In another working paper, The President's Duty to Commission Officers, I look at the commission clause of Article 2, pointing out that the purpose of the commission clause was to obligate the president to respect appointments that are proper under statutory law and under the appointments clause. And the inclusion of the commission clause, I think, is quite strong evidence that the framers did not have the unitary vision. That is, they recognized that there would be at least some situations in which there were limits to the president's removal power. Otherwise, I think it's difficult to understand why they chose to include this provision in the quite sparse text of Article 2, and other scholars have made similar arguments about other provisions of Article 2, such as the opinion clause. I would say more broadly, separation of powers should be an area in which courts are the most cautious about disrupting the legislature's policy choices, precisely because, as the court says in Collins, as we have explained on many prior occasions, the separation of powers is designed to preserve the liberty of all the people. And so it seems to me that we're in territory quite close to the public rights idea in cases like Lujan, that the arguments for limiting private plaintiffs' ability to enforce public rights apply even more forcefully in cases challenging the structure of government. So one concern we might have is a concern about justiciability. We might think that presidential removal restrictions create a political question that's inapposite for judicial resolution. I think a lot of the famous Baker versus Carr language applies pretty well to this kind of situation. Textually demonstrable constitutional commitment of the issue to a coordinate political department, the necessary and proper clause, a lack of judicially discoverable and manageable standards for resolving it. What is the content of the executive power? Is that manageable? The impossibility of a court's undertaking independent resolution without expressing lack of the respect due coordinate branches of government. Well, here we're talking about statutes passed by both houses of Congress and signed by the president. So there are some serious justiciability concerns, I think. There are also some serious standing concerns that I hope we have time to talk about. In fact, there's a strangely permissive standing doctrine in presidential removal cases in view of the concerns that standing precedents such as Lujan have had. And in fact, the doctrinal standing issues are closely tied to the remedial challenges that we're particularly interested in today. In these cases where a private litigant challenges an agency's structure, alleging unconstitutional limitation of the president's removal power, it's very difficult for them to show causation. That is, if they have a valid constitutional claim under which they suffered injury, the injury must be traced to an act that exceeds the agency's authority, as the court recognizes in Collins and similar cases. Yet these cases challenge acts that were clearly within the agency's authority. The appointments were proper under the appointments clause and within the agency's statutory authority. The agency had the authority to engage in the actions that are challenged, whether an enforcement action or the kind of action at issue in Collins. And the majority recognizes this. Indeed, Justice Thomas's concurrence in Collins acknowledges a version of this problem, but doesn't go all the way and recognize that it's a reason not to decide the case on these grounds. And finally, I just want to close by acknowledging that so much has happened in the last week that I think is a damning indictment of the unitary executive theory. We've seen the firing of an independent agency head, National Labor Relations Board member Gwynne Wilcox. People in this administration clearly believe either that the court will overturn Humphrey's executor or that the executive doesn't need to pay attention to what the court thinks. We've seen other developments along the same lines, the firing of 17 inspectors general in defiance of the statutory waiting period. More troublingly, the firing of a number of prosecutors in defiance of civil service protections. People in the administration have said that they have ambitions of firing many more government employees. And so I think what we're seeing is that the unitary executive theory, supposed to be a device that promotes liberty, will turn out instead to be a device that enables extreme corruption and personalism in government. And we need to wrestle seriously with those consequences. More broadly, I think we should think about the message that it sends when the court says that the president can disobey the law. Ultimately, all that Congress has to vindicate its position within the separation of powers is public acknowledgement that its acts carry the force of law. And when we degrade that, I worry that we degrade the rule of law and the separation of powers.
All right, we've gotten a lot. And I mean, Ellie, do you have kind of any, because you're kind of focused more on remedies, Dave's, I think, focused more, a little bit more on the substance, although I do want to get to where I think it intersects with the remedies. But Ellie, kind of any quick responses that you have, or?
Yeah, I think, some good points there. I will just note, in terms of the president disregarding what we might call law, right? We're talking about statutory law. And to the extent that statutory law conflicts with the Constitution, to the extent that the president is carrying out a removal that he believes is consistent with the Article 2 power, then the president is not in fact disregarding the law. The president is following the law. I think for these different agencies and for these different removals, we want to look at the statutory schemes. We want to think about what exactly are the statutory restrictions, to the extent there even is a statutory restriction on, one agency or another. Some have been presupposed. SEC independence is an example for a while. I think it's just been supposed that the SEC is independent, maybe notwithstanding statutory protections. In other cases, the president may have an argument that a statutory either waiting period or a statutory removal protection unduly trammels on the Article 2 power. And so I think, at least just in terms of my initial reaction, the only thing that I would be especially careful of is this idea that the president is not following the law. The statutes are certainly a body of law that exists, but they exist against the backdrop of the constitutional Article 2 powers that the president possesses. And we can get into, some discussion about what the contours of that are, but I think in terms of the lawfulness of the action, I think the idea is that it is indeed pursuant to law.
Yeah, I was curious, what do you think, Ellie, is the best response to kind of David's closing argument that if this is what separation of powers means and the president can fire anyone that works within the executive branch without cause, including civil service, that this isn't really about liberty anymore? I mean, how would you respond to that? I mean, just because the Gorsuch idea of separation of powers, we're trying to separate the powers and different, to promote liberty. Is that vision just destroyed in a world where the president has plenary power to fire anyone?
Well, I think at least at the initial outset, right, liberty is one argument. The president's power to steward and supervise the executive branch as an inherent element of that separated power, I think is, if you take a step back, maybe the more important argument. And so the ability of the president to supervise all, maybe we make a distinction between employees and officers. And I think there's some good scholarship on this. I direct folks to Jen Mascott's very good article in the Stanford Law Review on who are officers in the United States. But at least as to, the officers question, The idea is that the president superintending the executive branch does over time tend toward liberty because the president is an accountable official who is elected, as opposed to, folks who maybe enjoy independence, but answer to no voters. And so I think, at least in terms of the separation of powers, maybe at the initial outset, as to, you could point to, one removal or another removal and say, well, as a policy matter, this is how I feel about that removal, or maybe I really liked the work that XYZ commissioner was doing. But I think that's independent of the question of whether the president can supervise the executive branch and what the meaning of Article 2 is, because I do think it tends toward liberty, but liberty is maybe one goal, as is following the constitutional text.
Yeah. So if I'm hearing you right, maybe there's a distinction, or there should be a distinction between employees and officers. And then maybe there should also be a distinction between principal and inferior officers. David, the question I had for you to kind of kick us off, I mean, assuming that you have to kind of go along with the substantive holding in Collins, do you think that they got the remedy right? Maybe that's unfair, but I'm a law professor. I can make you not fight hypos. Like, is that the right remedy in your mind?
I think it's hard to say that it is. I mean, my view is that it points to a deeper contradiction in this doctrine, that if that's the remedy they're going to offer, they never should have decided the case to begin with, because there's no standing for this plaintiff. I think Saylor Law and Collins are both arguably cases where the plaintiff supposedly wins and walks away with nothing. But I think that shows that the court doesn't have the courage of its convictions. It's not willing to go where the logic of the theory would lead it. And that's quite telling. The court recognizes that the consequences of fully endorsing the unitary executive theory would be so disruptive to the structure of government and the people whose settled expectations have developed around the way the government has worked for a long time, that it is not a place that they want to go. I think that should make us ask a more basic question about this doctrine. And one way I think of putting it is, something philosophers sometimes say: one person's modus ponens is another's modus tollens. So the modus ponens take would be, because the unitary executive theory is correct, plaintiffs bringing claims under it must get a real remedy. There's no right without a remedy. The modus tollens take would be, well, because it would destroy the fabric of government to give these plaintiffs a real remedy, that suggests that the unitary executive theory can't be correct. There have to be some limits that the court has not yet acknowledged, but that perhaps are implicit in their unwillingness to deliver a more satisfying remedy in these cases. One thing I would say, also responding to Ellie's observation a minute ago, is I think there's an underappreciated distinction between what we might call the president's two bodies. So there's the individual person who occupies the office, and there's also the office of the president. And it's not clear from the Constitution's text which of those roles really should be the operative role in overseeing the operations of the executive branch. You could make a case. I don't think that people have adequately made this case, but you could make a case that we should put more weight on the institutional office of the president, and that preserving the ability of the office to engage in appropriate oversight functions within the executive branch is more consistent with Congress implementing these legislative schemes than people who focus on the person of the individual president would think.
Yeah, I mean, so on this standing point, I'm kind of curious to get Ellie's take. I remember when I taught Fed courts right after Collins came down. By the way, I have to kind of confess, Collins, one of my regular co-authors, Aaron Nilsson, was appointed by the court to defend the Federal Housing Finance Agency, and he enlisted me as his co-counsel. So we spent he spent a lot of time. I spent dozens of hours. He definitely spent hundreds of hours trying to kind of save this agency, and it was so painful to read Justice Alito's opinion, because Justice Alito answers every single argument you make. And we included a lot of arguments that weren't great. I mean, we included every argument you can think of, because as an amicus, what do? Right? You don't have a client. You can't say which arguments can be not in event. So it was not a fun opinion to read. But when we got to the remedy, and I was teaching standing, I was and teaching Lujan, and and talking about injuries can't be speculative, and causation has to be fairly traceable, and whatever the court's going to order, the relief actually has to remedy the wrong, and I don't know, Ellie, like, is there standing if Collins, the remedy in Collins is the remedy that you get for separation of powers violation?
Yeah, so I think it's difficult, right? And there are some cases that Collins still acknowledges where you might have a remedy. So, for example, the hypothetical I gave earlier, the president actually does remove the official. That official, goes to, and we can get into like what the remedy for this kind of suit should be if this is even a reasonable hypothetical that would happen. But let's assume that official goes to, I don't know, the Court of Federal Claims and says it was unlawful to fire me, see the statute. The court does not buy the constitutional argument. And the official proceeds, let's say, under a court-ordered injunction to continue being the head of that agency and continues to take action in contravention of the president's agenda. Then you might be able to say, I actually am being harmed by the removal protection, or at least the court-ordered injunction that misconstrues the relationship between the Constitution and the removal protection. In that instance, you might have a situation where you can obtain a remedy and you do have standing. There was another case, and I actually haven't followed what ended up of this case or where this went. And I hope I get the facts correct here, but it's a District of Minnesota case. And in that particular case, the litigant comes forward in, I believe, November of 2021 with a letter from, at the time, former President Trump to Senator, I believe, Rand Paul, saying, this official who took this action that by which you were aggrieved, I would have fired that individual. And the district court says, I can't rely on the validity of this, later in time letter, especially now that there is a different president in office and what exactly would have happened. And my understanding is the court allowed the agency action to proceed and relied in part on Collins. So I think there are some cases that do survive Collins. The second order question that you might ask here is, are we thinking about this correctly? In that we're looking to see whether it's some abstract right that you have to the separation of powers is the better way maybe to think about it. And I think Will Yeatman maybe has a Yale JREG post on this, where maybe we think about it as something like a right to a constitutional proceeding, that the very existence of that removal protection makes the agency official act and believe and administer the laws in a way that's indicative of feeling free and independent, notwithstanding whatever the president ultimately ends up doing. And there you might mix some of the Article 2 provisions and get them in by way of, we might call it due process or some other constitutional right. I don't know. I haven't studied that one as closely, but there is precedent for the idea that some proceedings, especially we can get into this later, in the judicial context might be tainted, for example, by the existence of an unconstitutional removal protection. We might call it something like bias. But I think there are standing puzzles still to be resolved, and there's a lot of hypotheticals that we may well end up seeing within the next several months, depending on how robust the Trump administration wants to be with its asserted removal authority.
Yeah, well, let's complicate this a little bit more. I mean, I flag on that. I mean, I think when the theories that were going to say the law in Collins were kind of the idea that this is a structural constitutional issue, and like the injury should be presumed, right? Kind of like similar to we have a criminal on it. Court clearly did not embrace that, right? So that's kind of an interesting dynamic. But then we have Axon, which I don't know what to do with Axon. So the Supreme Court's asked, does in a particular agency context, can an individual that's in an agency adjudication that thinks the adjudication process is unconstitutional or otherwise exceeds the authority of the adjudicator? There it was a dual error removal issue, similar to kind of what we're talking about here. Do they have to wait for the adjudication to be final and then appeal, or ask for review by the Court of Appeals, or can they run to a district court and get a preliminary injunction and eventually a judgment that it's unconstitutional? And the court says, I think it's a unanimous decision, right? The court says, written by Sotomayor, I think. If I remember this right, maybe I remember it wrong, but says, hey, yeah, you can go to district court. And when does it go to district court? Well, that's the statute it seems to allow it, right? Like it's a weird, but also like these are really, really important rights, these constitutional structural rights. And I kind of wonder how that fits in. I mean, if they aren't important unless the agency official would have acted differently without the removal protection, how does that fit in? And just to kind of flesh that out a little bit more, the lower courts right now have taken an approach where they are, oh, it's a Kagan opinion. Thank you, Ellie. You're being way too kind there. Where the Fifth Circuit is going full force and saying the district courts of Fifth Circuits are just enjoining every single agency adjudication that comes before them, and eventually we're going to find out if that's the right answer in the SpaceX case. That's like there are 3 cases that are consolidated for the Fifth Circuit. I think oral arguments next week. Other circuits like the 10th Circuit look at that and say, I read Collins, and these aren't irreparable harm, so a preliminary injunction is not appropriate, because you got to be able to show that the ALJ would have acted differently without the removal protection. So I kind of wonder, Ellie, like, how do you square, and maybe Dave, you can jump in too, but man, like, how do you square kind of the Axon moves that we're seeing in the district courts with Collins itself? And to be clear, I also should confess, we filed an amicus brief. I'm counsel for the U.S. Chamber of Commerce in the SpaceX case. But like there, I think the argument was like there's something like it's prospective relief and not retrospective relief. So one way to think about Collins is, are we going to undo a huge deal that was made by the Federal Housing Finance Administration, as opposed to, are we going to allow for an unconstitutional proceeding that's occurring right now to continue? Ellie, do you want to start, and then we'll switch to David after that?
Sure, I'd be happy to. And I think the SpaceX case is another really interesting one where it fits into this broader theme of, yes, Collins says what it says about standing, but Collins at the same time acknowledges, as I just laid out, there are some of these cases that may indeed proceed to the merits and may indeed proceed to meaningful remedy. So maybe the retrospective versus prospective relief distinction is one of them. And so if that does exist, and if you've put in, say, your complaint, you've dutifully alleged that this case falls outside of the Collins exception, well, adjudicating that question to me strikes me as more of a merits determination that maybe gets you past the standing inquiry. And Axon seems to stand for a principle of, we at least want the merits determinations to be made and adjudicated in the federal courts. And so, perhaps it's the case you under Axon get to go to a federal court and they determine, as the district court in Minnesota did, well, this particular fact pattern may rhyme with one of the exceptions that Collins acknowledged, but it's not enough. I'm not going to do this based on a letter that a former president issues after that president's term is over. But at least you get to the merits, and you get to do the merits in an independent tribunal under Article 3. So I think maybe it may well be the case that some of those Collins principles end up coming back to bite you in the merits phase. And I don't know, maybe they do, maybe they don't. The courts are working through this. But at least on the standing inquiry, I think Axon seems to favor a policy of letting you go to federal courts.
No data thoughts, yeah.
Yeah, so a couple of thoughts. One, there's something deeply weird about the position that a plaintiff is taking in this kind of case. They're saying, I was subject to an action that the government had the authority to engage in. There's a statute that specifies certain things as falling within the scope of the law. The agency recognized my in an ALJ case, the agency recognized my conduct as falling within that scope. And I'm not even challenging whether the agency was right. It could be that my conduct fell within the scope of the law, and so it's appropriate to take an enforcement action against me under the statute. What I'm instead challenging is this procedure that has no bearing on whether my conduct violated the law. So I think that's the missing part in the, it's partly a standing question, but it's also, the real issue there is it's not necessary to take up that issue to dispose of the legal rights of a plaintiff in this kind of case. So that brings me to the second issue, which I think Ellie makes a really interesting point, that it could be that the right that's at issue is the right to a certain kind of procedure, a constitutional procedure. And that's a really interesting suggestion. I'm actually sympathetic to that way of thinking about the issue, but I think it runs into two problems. One is the kind of justiciability reservation that I opened with, right? Is these are structural choices. These are not fundamentally choices about individual rights, and so we might want to think about them differently as involving something more like public rights. The second puzzle, I think, is that that's not the way that courts in recent decades have tended to think about due process cases. In due process cases, we're really focused on how will this change the result that the plaintiff gets. But if that's the way we're thinking about due process, when it seems all the more relevant to ask whether the procedure is one that the plaintiff is entitled to, it seems puzzling to me why we would think that way about a structural, an inherently, essentially structural question like the ones we're talking about.
Yeah, I would just kind of, I think, jump in here and you know, the other kind of like follow on that I often hear is, well, if the agency head has final decision-making authority anyways, which the vast, now if there are probably in almost all agency adjudication, that's the case, how is there any kind of harm at all from this? And at least how Aaron Nilsson and Melissa Wasserman and I kind of frame it, and I'm going to echo something that Kevin Walsh has in one of in the comments, is that the APA was designed to have a certain vision of the standard model of agency adjudication, where the agency adjudicator that makes the facts and creates the record, the administrative law judge, has all this sort of decisional independence from the political side of the agency. They're hired and fired based on merit. Their pay is not tied to whether they agree or disagree with the agency head. There are all these sorts of procedural protections to make sure they don't have ex parte communications. And the whole idea is you want the trial level adjudication to be as impartial, as unbiased, as neutral as you can. Is it perfect? No, but you try to get it close to a judicial proceeding as you can. And that the second stage, though, is that the agency head has the final say. And that agency head, when they make the final say, can look to political or small p political or policy reasons for making that. And if they're improper, the Court of Appeals, the public, the parties can look at that proceeding because it's all on the record and decide whether it's arbitrary and capricious. And so I think there's a pretty good argument to say that the standard model under the Administrative Procedure Act, it was a grand bargain, was a vision that Congress had in 1946. And that if you're trying to kind of say those ALJs don't have that decisional independence, you really can't sever Congress's decision to have that decisional independence from the statutory scheme. So I think that's another argument you're seeing in the Space Act cases and some of these other cases that are coming up, is that at least when it comes to administrative law judges, you can't sever it. I'll say in Arthrex, when the court, remember Arthrex in this case, we had the administrative patent judges that had final decision-making authority, and the Supreme Court said that's a constitutional violation. And the response was, well, how do we remedy that constitutional violation? Well, the Federal Circuit said, well, let's just strip all removal protections of the administrative patent judges, which are actually just the civil service. They're not administrative law judges. They don't have heightened removal protections, but they do have civil service protection. And I think that Chief Justice Roberts for the court was like really, really careful in not doing that and say, no, instead let's actually just rewrite the statute and remove instead the prohibition on final decision-making authority by the agency head. I'm not actually sure that was, as a matter of severability, that was, it struck me as something that only Congress could do, because that was a very conscious decision by Congress in the Americans Invents Act not to allow for agency head final decision-making authority. I'm actually not sure we'd have a patent adjudication system at the agency without that, or it might look dramatically different. So I don't know, Ellie, or David, whoever wants to jump in. I mean, what do you think about this this argument about severability and that being kind of an important part of understanding both standing and the remedy?
Well, so two thoughts about this. One, I mean, clearly this is not something that the Congress is enacting these statutes could have been thinking about, because courts hadn't told them it's something that you need to be worried about. This is a very recent novel doctrine that Congress would have had no reason to anticipate in making these design choices. I mean, just to jump in though, I don't think Congress in 1946 would have created an administrative adjudication system where administrative law judges are removable at will. I mean, the whole I think that's plausible, but if for the court
was they wanted these, yeah.
For the court to come back and say that's a reason to invalidate the whole agency, which is one direction you could go, would be really dramatic, given that there was no question in 1946 about Congress's authority to design an agency. this way. So I mean, so I think that's another really big concern. On the dual layer issue, though, I mean, I think it's true, as you observed, that one way the court could deal with this, could reconcile Peekaboo on the one hand with Sailor Law Collins on the other hand, is that they could say, okay, the implication of Sailor Law Collins is that we're heading in the direction of overturning Humphreys. Maybe they are going to say that, and once we've done that, that's enough. Then we've solved the dual layer problem, and we don't need to come for court-like procedures at the ALJ level. So that would be coherent. I think it would be normatively troubling, but I think it would be coherent. You could also push back against the dual layer argument in a different way. You could say what was going on in Peekaboo is very different from what's going on in the ALJ dual layer situation, because in Peekaboo you had two layers of agency heads, which is the kind of situation that we were really concerned about in a Sailor Law type situation. And the same underlying concerns don't really apply to the kind of work that ALJs are doing. Now, one way that you could make that argument would be to rely on the language of Humphrey's executor about quasi-judicial roles. I never found that particularly satisfying. I doubt that the formalists on the court find that particularly satisfying. But it's worth observing that even in Myers, the court was bracketing ALJ protections from the kind of issue that it thought was significant in these sorts of cases.
I want to get back to the dual layer in a minute, but I first want Ellie to kind of respond. Yeah.
Yeah, and in fact, the point about Myers is correct. And I'll add also that in 1958, the court decides Wiener v. United States, where they seem to think that maybe adjudication is at least in a different place as the pure, I guess you might call all of it pure, but really the pure exercise of executive authority. I will note, however, stepping back from the removal question as to ALJs, Justice Thomas acknowledges in a concurrence in Axon that maybe this whole idea of assigning administrative agencies with adjudicatory authority at the front end is unconstitutional. Evan Bernick has a good article where he suggests that maybe the serious judicial deference to agency fact-finding is unconstitutional on due process grounds. And so I think there's multiple ways to get to what the core discomfort is that I think some of these litigants are articulating when it comes to administrative law judges. It may well end up being the case that an ALJ is removable at will, but the real problem is that you eventually end up getting into an Article III court with deferential judicial review on the actual facts that the ALJ has determined, often without the core protections that you might have for the development of evidence, for example, in a federal court, or other procedures that are designed to ensure that evidence that gets into a proceeding is reliable, is truthful, and ensures that the proper result is reached. And so I at least just don't want to get distracted on the ALJ point by just thinking about it in the narrow context of removal, especially given what the court has said about adjudicatory officers in the removal context, when it seems that a lot of the energy is on the broader constitutional questions of, well, what are we doing in terms of adjudication in agencies vis-a-vis first level adjudication in the federal courts?
Yeah, so you brought another question up real quick, David, before you go in. So the mixing of the separation of powers with the due process stuff drives me crazy. I mean, I feel like the separation of powers challenge is just kind of completely blown up the administrative state. The reason I mention that is all of your arguments you just made, in my mind, just only matter if you're dealing with private rights. And probably 5% of all adjudication, and at least 90% of all adjudicators don't actually ever adjudicate a private right. They're doing public benefits cases. And so I think this kind of idea, we're worried about this, it's different. Now, maybe you could make an argument. I think David was kind of gesturing at this. Maybe there's an argument to make that when they're adjudicating just public benefits cases, they don't have the same level of officer, the significant, wielding significant executive power. Although my mind is public benefit cases are kind of any event. So I'm curious. I just kind of wonder how. And there are a few questions in the chat that are also really kind of hammering this home of, should we be thinking about these things differently if it's a public rights or public benefits case versus a private rights case. I don't know, David, it seems like you might have been going in that direction too. Any thoughts?
I think those are important arguments to be exploring. I do want to push back a little bit against the idea that giving agencies enforcement power is somehow diluting or segmenting the executive power. I think, and there's actually some really interesting work on this question happening right now. It's far from clear that even prosecution was historically understood to be at the core of the executive power, much less civil enforcement, much less proceedings that occur under the rubric of agency adjudication. So, I mean, I think we need to be very careful about the arguments that we make about the meaning of the executive power. We're talking about a term that we're talking about one word in the Constitution, and deciding whether on the basis of that word we're going to disrupt decades-old precedents, decades-old arrangements that regulated parties plan around, and decisions that the political process has made. So we need to be really sure. If we're going to do that, we need to be really sure that it actually is an accurate understanding of that term. And I just don't think that we can say with enough confidence that enforcement was at the center of a widely accepted understanding of that term, or at least that's what a lot of serious historical work over the last year has suggested.
So we have 10 minutes left. I want to make sure we get through more of the questions in the chat. I'd flag Peggy Little from the National Civil Liberties Alliance has some notes about how the SEC dismissed all their open cases after Cochran, which is definitely, they did. I mean, I think generally they're just not doing adjudication anymore through with civil penalties because of jarcossy. I mean, they in large part, it kind of shut down their shop. But the other question I had is like a few of these we have here. Let's ask. So Aaron Watt's got a question. If private parties don't have standing to challenge removal powers, does the president need to fire agency heads to obtain a judicial determination regarding the right to do so? Any quick thoughts on that?
Yeah, so this is one that actually I talk a little bit about in this little Yale Law Journal forum essay that I had published. There's a parallel here, I think, with the good faith exception to the Fourth Amendment, where you might actually be disincentivized to bring cases involving these protections, because what's going to happen is on remand, in the Fourth Amendment context, let's say you bring a novel Fourth Amendment argument and you end up winning. I think this actually happens in Carpenter v. United States about cell site location information. As it turns out, there was a search, and then they go back and in the lower court, they say, well, but the police relied in good faith on what their understanding of the constitutional protections were. Thus, there's going to be no remedy here. Similarly here, you might say, well, it may well be the case that the official was unconstitutionally protected from removal, but you personally were not harmed by that, and so we're actually not even going to reach the issue, and so the president gets no determination as to whether or not the official was unconstitutionally protected. I think Justice Thomas's opinion makes it, or I should say Justice Thomas's concurring opinion in Collins makes it incumbent upon the president to understand what the full weight of the vesting clause, obligation or power, you might say, is. And so it may well be the case that we get a lot of the development of this law going forward through presidential assertions of a constitutional override of some of these statutory protections. And this, I think, is how a lot of this law developed anyway. The through line from, let's say, Myers to Humphrey's executor ends up being these are cases that are brought by people who themselves were removed, and they assert that removal was done illegally.
Yeah, and we're going to probably see one of those cases soon with the firing of one of the members of the NLRB. Any hot takes on what's going to happen if it reaches the court? David, what's your thought?
I wouldn't put it past this court to overrule Humphrey's executor. I mean, I think this is an area that has taken on a lot of expressive significance that goes beyond even the doctrinal significance. So I really wouldn't be surprised. I would be horrified, but not surprised.
I would just, if I may briefly say on this, I think there's a lot of energy around the idea of overruling Humphrey's executor. And I think there is indeed some rhetorical value to it, but it's also the case that we're talking about a different agency here that has a different set of statutory powers. Indeed, the FTC itself today has a different set of statutory powers than it did in 1935 when the Supreme Court decided Humphrey's executor. And so it may well be that the Supreme Court or a lower court reviews, what the NLRB exactly is able to do and says it, for example, has a prosecutorial power that the FTC did not in 1935. And so had the court been confronted with a statutory scheme that looks like this, as opposed to what the FTC's powers were, which were more, again, adjudicating in the first instance before going to an Article III court, or preparing reports for Congress, that was the quasi-legislative function, the court might say this is actually distinguishable, and maybe they want to overrule Humphrey's executor, but I think the court also has an off-ramp here to say Humphrey's executor need not be overruled because we're talking about the NLRB and it's a different agency with different powers.
Yeah.
And just going back to just very quickly, this point about whether even prosecution was at the core of the executive power. There were private prosecutions in England, in colonial America, and in the early Republic. So I think it's hard to make the case that even prosecution is an inherently necessarily public executive function.
Yeah, I would note that this issue that the NLRB is different than the FTC has been briefed in a lot of cases over the last year or so. I think even the SpaceX case doesn't as much, but there was a cert petition that made its way all the way up to the Supreme Court saying the NLRB, the removal protections here are unconstitutional, even if the Humphrey's executor is still good law for the reasons Ellie mentions. And the Supreme Court denied cert in that case. But they're not going to deny cert, I don't think, in a case where the person who was fired comes and asks for a ruling. So that'll be kind of interesting to kind of sort out. But I agree with Ellie, there is a way for them to keep Humphrey's executor if they wanted to, and just kind of continue to chip away at it, which seems to be what Roberts has done since he got on the court. I guess the kind of elephant in the room on that is the Fed. There are definitely a number of theories out there that the reason we still have Humphrey's executor, and it's not, Chief Justice Roberts only overrules one case a term, but he could have made room for Humphrey's executor at some point, right? Is the Fed really stopping the court from kind of going all the way? Is there a way to distinguish the Fed? I mean, feel free to take a pass if you haven't thought about it too much. But my guess is the justices are thinking about that a lot when they're looking at these cases. David, do you have thoughts?
Well, I think a lot of people would say the Fed is on far shakier constitutional footing than many agencies, because the real issue is not a removal issue, it's an appointments issue. I think there's serious doubt about whether the design of the Fed comports with the appointments clause. That said, there are going to be standing obstacles to challenging it, probably more effectively than in many of these cases.
I mean, I will just flag what I think is one of the better pieces of scholarship on this question. Aditya Bomzai and Aaron Nielsen, who we talked about before, have an article in the Cornell Law Review, Article 2 and the Federal Reserve. I think that's the title, where the two of them try to bifurcate what I think a lot of people are worried about when we talk about the independence of the Fed. And what I think we're really worried about is not, whether Jerome Powell gets to keep his job in particular, but the question is whether monetary policy is going to be independent of political influence, bracketing the question whether that independence is desirable or not. It may well be. I think Bomzai and Nielsen take the position, indeed, you can remove governors of the Board of the Federal Reserve or the chairman of the Federal Reserve. In fact, you might even say that the statute is more permissive than it is for some of these other agencies like the FTC. I believe it just says for cause. And so I think, maybe the president there would have even a stronger argument that I actually am complying with the statute, and the cause is that this, governor of the Federal Reserve is not implementing my vision for the statutory mandate for this agency. But Bomzai and Nielsen walk through some ways where, notwithstanding if the Supreme Court does become interested in that question and does what this conversation suggests it might do in some other agency context, where you still may be able to have independent monetary policy, regardless of your view of the merits of that independence as a policy matter or whatever else. But I commend it to the listeners to read.
Any thoughts, David? Or I've purposely kind of stayed away from originalism arguments because my colleague right next to me, Julian Morrison, might start pounding on my door and tell me to knock it off. I mean, I will say, reading Aaron and Aditya's article, I mean, the one thing that's like hard about that is like, it feels like an elegant solution, like carve off monetary policy from regulatory authority. And yet, like, you can't really, the Fed's not designed to do monetary policy without regulatory authority. And I also might invoke a little bit what Kevin Walsh said. Congress didn't design the Fed in a way to just do monetary policy without regulatory authority. Again, I'm not a historian. I don't do originalist work because I'm not smart enough to do it. But like the first and second banks also had a lot of regulatory. I mean, it's just, I'm not sure it works. Even though I think it seems elegant. Not that you shouldn't read it. I mean, it's obviously a very illuminating article. But I was left kind of thinking, I'm not really sure if Chief Justice Roberts reads this article that it's going to give him enough comfort that to draw that line. I don't know, David, do you want to jump in?
Well, I think this is the deep puzzle in this area of law. That the more we invent these distinctions, the harder it is to attribute them to the constitutional text. I mean, I saw peekaboo as an example of this problem. The dual layer issue is nowhere to be found in the text of Article 2. It's a rule that has been completely invented by the court. And I think it's hard to call that formalism. The more we do that, the more we should have deeper qualms about the justiciability issues, because these are really policy decisions that ought to be made by the political branches.
I like progressive formalists. That's all I've got to say. I'm glad it's a fun, because that was not the history of the last 70 years of the court when we came to creating constitutional law. But I do think, yeah, I mean, we could have a whole panel on the dual layer removal, and I actually hope we'd have more time, but there's so much to cover, and we're at the hour, and we didn't get through all of the questions in the chat, but I try to get through a lot of them by how we asked them. If you have more questions, feel free to send them to Ellie. He'll answer them and then send you a bill. David and I might answer them. I don't know, but it's been really, really fun to have this great conversation with just two really smart people that are thinking about these really difficult questions.
Well, I'll jump in and echo those thanks. Really appreciate you, our panel, for joining us and sharing your valuable expertise and insight. It was a fabulous discussion with a lot of back and forth, and we covered a lot of top ground, so really, really appreciate it. Thanks also to our audience for joining and participating. Welcome listener feedback by email at fedsocforums@fedsoc.org. And as always, keep an eye on our website and your emails for announcements about other upcoming virtual events. With that, thank you all for joining us today. We are adjourned.